My name is Fergus Mackay. I'm the Senior Legal Counsel at Indigenous Peoples Rights International. I have the pleasure of moderating today's side event, which is on the report of the Special Rapporteur on the independence of judges and lawyers on Indigenous legal systems. I will introduce my fellow panelists in a minute, but let me just introduce the subject by thanking the co-sponsors of the event, which are the governments of Denmark, Finland, and IFGIA and Indigenous Peoples Rights International. We're going to start with an overview of the report that the Special Rapporteur is going to do, which will be followed by comments from two distinguished Indigenous women who are both judges in their own legal systems in one way or another. And Mariana here was a judge on the Supreme Court of Ecuador as well. So we have some very distinguished colleagues on the panel with me. We're also hoping that the Special Rapporteur on the Rights of Indigenous Peoples will pop in for 5 minutes. He's in the interactive dialogue in the other room, but hopefully he can come in and share his thoughts on Meg's report, which is a very important report, as we'll discuss in a few minutes. After some closing remarks, hopefully from Finland or Denmark, we will then move on to any questions from the floor. And I'll try to keep everyone on time because I'm sure people do have questions and we usually run out of time. So I'll try to make sure that we do have time for questions. Yeah? The subject of the report, Indigenous Peoples' Justice Systems, is important because, as the report highlights, these systems are a key component of self-determination. And for me, more importantly, an example of self-determination in practice. Rather than talking about it and using the words rhetorically, Indigenous justice systems are self-determination in practice to the extent that people are using them and they're able to do so freely, hopefully, right? They're crucially important to various other human rights, including cultural integrity, access to justice, in some cases spiritual, religious rights as well. These rights are, as affirmed in the report, firmly guaranteed by international human rights law, both in the Universal Human Rights Treaties adopted by the United Nations and also in the UN Declaration on the Rights of Indigenous Peoples, which is essentially restating existing law on these points. The report had its genesis in a discussion about how to ensure the independence of Indigenous justice systems, both on their own and as they relate to the justice system of the state. So there's two dual aspects to it. One is the right of Indigenous peoples, where they so choose, to maintain their own justice systems however they understand them, and how the state's justice system either has to accommodate those or to modify the way it works in order to give full faith and credit, respect those Indigenous justice systems, including as it relates to access to justice within the state's legal system. But Meg will speak about that in more detail. I think it's important to note that this report builds on prior reports, including one done by Vicky Taule-Kopuz when she was the Special Rapporteur on the Rights of Indigenous Peoples, and also on prior recommendations by previous Special Rapporteurs on the independence of judges and lawyers. So it doesn't come out of the blue, it's building on prior work. And in my view, builds very well and advances that prior work in a way that hasn't really been done by anybody else that I've seen so far. Right? It was presented to the Human Rights Council at its last session, and the response from the states was overwhelmingly positive. So with that in mind, I will pass it over to Margaret Satterthwaite, who is the Special Rapporteur on the Independence of Judges and Lawyers. Meg, we all call her Meg. And Meg will speak for 10 minutes, and then we will come over to our colleagues over here. Thank you.
Thank you very much, Fergus. And good afternoon. It's really wonderful to be here. And I want to also thank the states of Denmark, Finland, and also, of course, this important support and co-sponsorship of IFGIA and Indigenous Peoples Rights International. And without the collaboration shown throughout the preparation of the report, this report would not exist. So I want to thank them. Excellencies, distinguished members, esteemed representatives of Indigenous peoples, and honored participants. It's a privilege to join you today in this vital space of reflection, solidarity, and action. I'm deeply honored to speak in my capacity as Special Rapporteur on the independence of judges and lawyers. For countless generations, Indigenous peoples have repaired harm and ensured and maintained balance within communities through their justice systems. Indigenous peoples' justice systems have also advanced access to justice for Indigenous peoples. They resolve disputes, restore harmony, and protect rights in ways that are culturally resonant.
There's no translation.
There's no translation, so I don't have to slow down, is what you're saying.
No, the translation isn't working.
Oh, should I stop?
Yeah, just
Okay. You
Oh,
can hear
it's
it.
a
You can hear it.
No.
But it's a good reminder not to talk too quickly. Indigenous peoples' justice systems include mechanisms, laws, and processes pertaining to a wide range of disputes and important matters, including the use and management of territories, issues of governance, family, and spiritual matters. The principles and practices of Indigenous peoples' justice systems are often deeply embedded in the daily cultural practices of Indigenous peoples. Studies have shown preferences among many Indigenous peoples to use their own legal systems where possible. Studies also show that there's less crime, more durable conflict resolution, and greater biodiversity on the lands where Indigenous law is freely applied. Indigenous peoples' justice systems are also inextricably tied to self-determination of Indigenous peoples, as Fergus emphasized, and thus an element of their identities, continued survival, vitality, and development. And I want to take a moment to emphasize that the right of Indigenous people to self-determination, a right affirmed in the UN Declaration on the Rights of Indigenous Peoples, and numerous other sources and affirmations of international law, includes the right of Indigenous peoples to develop, operate, and preserve independent Indigenous justice systems. The Committee on the Elimination of All Forms of Discrimination Against Women, the Committee on the Elimination of Racial Discrimination, and the Committee on the Rights of the Child, as well as the Human Rights Committee, have all reaffirmed the importance of state recognition of Indigenous peoples' justice systems and the need for these systems to ensure human rights, including women's equality, the right to a remedy, and fair trial standards. The expert mechanism on the rights of Indigenous people has itself emphasized that states should recognize and provide support for Indigenous people's own justice systems and should consult with Indigenous peoples on the best means for dialogue and cooperation between Indigenous and state systems. Still, the recognition of Indigenous people's own justice systems and customary laws remains limited, and their status varies greatly across countries and regions. In some states, these systems are not recognized at all. In other places, the ordinary legal system neither recognizes nor prohibits Indigenous people's justice systems, leaving some space for de facto exercise. Still, other countries have officially recognized Indigenous people's justice systems but place restrictions on their jurisdiction or subordinate them to ordinary courts. And I'm sure we'll be hearing more about that from our two Indigenous judge colleagues. For these reasons, my report examines good practices and remaining challenges to the recognition of Indigenous people's justice systems. But some might ask, why would this rapporteur write this report? Why not have this report written by another mandate? My response is twofold. First, my mandate requires me to record and respond to attacks against judges, lawyers, and other justice operators. Indigenous justice operators are under attack in many parts of the world because their justice systems are not accorded recognition and resources. This is within my mandate. Second, my mandate charges me with making recommendations on how best to improve justice systems. All judicial systems need improvement, and they can all do better in ensuring access to justice for all. Improving justice systems requires that state justice systems recognize and engage with Indigenous justice systems where they exist. The recognition and advancement of those justice systems will ensure Indigenous people's right to access to justice is fulfilled. This recognition will also translate into improvements in ordinary justice systems, which will better understand how to interact with Indigenous systems once they have a clearly recognized place in the national justice system. For these reasons, I'm confident that the report falls within my mandate, and I hope it's a contribution. The report builds on recommendations made by my predecessors, as Fergus has already mentioned, and recommendations made concerning the recognition of Indigenous justice systems, as well as drawing upon the work of the Special Rapporteur on the Rights of Indigenous Peoples, the expert mechanism on the rights of Indigenous peoples, and various UN treaty bodies and other international authorities. And I want to underscore that I'm deeply embedded to the input and writings of Indigenous judges, scholars, and leaders in preparing the report. Through collaboration with Indigenous peoples institutions and organizations, including Indigenous Peoples Rights International and IFIA, I conducted 13 in-person or online consultations and received 48 submissions in response to my call for inputs. The report seeks to foster dialogue on the role of Indigenous legal systems in resolving disputes, increasing access to justice, and advancing human rights. There are 3 areas of concern that the report highlights. First, lack of recognition. As I mentioned, in many places, countries do not recognize formally the systems of Indigenous peoples' justice. That absence is not symbolic. It has real consequences. Indigenous authorities have at times faced criminal prosecution simply for exercising their traditional responsibilities. For example, in Guatemala, Indigenous authorities have been charged and some remain in detention for playing their customary role within their communities. We also see entire Indigenous communities in Guatemala having been charged with land grabbing or worse, simply because someone else says they own the land the community has lived on for generations. These criminal charges are the result of legal systems that do not recognize the status of the land according to Indigenous justice systems. The second major issue is restrictive limitations placed on Indigenous systems. Where recognition does exist, it's often accompanied by jurisdictional constraints, such as geographical constraints, personal constraints, subject matter related constraints that undermine the full exercise of Indigenous authority. And finally, a real failure to adapt ordinary justice systems. Indigenous peoples continue to face linguistic, cultural, and procedural barriers in the ordinary justice system. Discriminatory attitudes persist and access to justice remains quite unequal. As outlined in my report to the Human Rights Council, international law is clear. Indigenous peoples have the right to maintain, strengthen, promote, and develop their legal institutions and judicial systems. Looking ahead and drawing on EMRIP's conclusions, the report underlines the state's obligation to adapt their ordinary justice systems to ensure access to justice. It then turns to what Indigenous scholar Beverly Jacobs has called blending justice. The ordinary justice system must adapt. That means ensuring legal aid and interpretation in Indigenous languages, incorporating cultural expertise into judicial proceedings, training judges, prosecutors, and police in Indigenous law and history, promoting Indigenous representation within ordinary judicial institutions, considering the social and historical context of Indigenous accused during sentencing, and shifting toward restorative models that center community healing instead of incarceration. Moving beyond adaptation, blending justice involves integrating Indigenous justice approaches, values, and practices into ordinary justice systems. This process allows us to pay attention to foundational standards such as dignity, which is essential to rebuilding Indigenous legal practices with cultural integrity within broader legal systems. This approach has gained prominence in countries where Indigenous peoples' justice systems have not been formally recognized, but where established legal traditions are de facto exercised in Indigenous spaces. Whether and how blending approaches may be appropriate is a question for Indigenous peoples and their relationship with state systems. On a positive note, around the world we're seeing examples of innovation. In Canada and Australia, Indigenous sentencing courts involve elders and knowledge keepers. In Peru and Mexico, protocols of coordination guide interactions between Indigenous and state jurisdictions. In New Zealand, Tikanga Maori is being integrated into law through both statute and jurisprudence, with courts convened on Marae to strengthen community ties. Finally, the report calls on states to ensure constitutional or higher order recognition of Indigenous justice systems to protect their autonomy and end criminalization of Indigenous authorities. It urges robust coordination mechanisms developed through dialogue and led by Indigenous communities themselves. As we imagine a future grounded in dignity, the answer is not to ask whether state or Indigenous systems should coexist. The question is, how can we build a legal order that respects both? In closing, I reaffirm my commitment as Special Rapporteur to defending the independence of all justice actors, including those within Indigenous systems. The future of justice is not uniform. It's diverse, grounded, and in many places, it is Indigenous. Thank you.
Many thanks, Meg. I'm glad you mentioned the issue of incarceration, because one of the consequences of not recognizing Indigenous justice systems and internally resolving disputes is atrocious rates of incarceration of Indigenous peoples in many countries around the world. In Canada, the Indigenous peoples are about 4% of the population, about 50% of the prison population. And you see similar numbers in the United States, in Australia, and in New Zealand as well, and not only, in additional countries too. So I'm very happy you mentioned that, because it's one of the outstanding human rights issues that really needs further attention. We have a slight change of schedule here because Dr. Barume has to go back into the other room. So we're going to let him go first, and then we'll come to our guests over here. So Albert, please.
I really apologize for being late. Really sincerely apologize. It's absolutely nothing to do with my goodwill. And it's really a pleasure to be here. I just want to make two very short points. The first one is maybe going to the point that my colleague Special Rapporteur just made about whether this is within or outside her mandates. I was in a country somewhere recently talking to Indigenous people, specifically in Indonesia, and one of my last points that I made to Indigenous people in Indonesia is to take advantage of other existing special procedures. We are almost 60. I listed those who can possibly be relevant to Indigenous people, and I strongly recommend Indigenous people to use the other special procedures, other special rapporteur, because I think the more special rapporteur working special procedures work on Indigenous people's rights, the stronger voice Indigenous people have. And this is my perception of being a special rapporteur, is a voice amplifier, if I can really put in one. We take Indigenous people's concern and we amplify them a little bit more for them to be heard elsewhere. So the many amplifiers, logically, Indigenous people can have, the better. So I really thank you. And I had the privilege to read the draft. It's something absolutely rich in knowledge. It's unprecedented. Nobody has done such a detailed analysis of a central pillar of Indigenous people's self-determination. The capacity of Indigenous people to look after themselves, including providing justice for themselves. So it's really wonderful. Last thing to say, I tweeted about it on my mandate. It's a wonderful report that I followed the presentation to the Council online. I think it's an invaluable tool that we should absolutely use because we all, and that's my last point, working for one single thing. It's a coherent body of knowledge on Indigenous people's rights. It really doesn't matter where a peace comes from if it contributes to that coherent, effective, strong knowledge on Indigenous people's rights is more than welcome. Thank you, Special Rapporteur. Really, thank you. And you allow me to excuse me to join the other meeting. Thank you.
Thank you, Albert. I'm going to introduce my friend Ekin over here, who is a judge from the Chittagong Hill Tracts in Bangladesh. But before I turn the floor over to her, I met her in a workshop about CEDAW's General Recommendation number 39 on the rights of Indigenous women and girls, which has a whole section on Indigenous legal systems and the rights of Indigenous women within those Indigenous legal systems. So to me, it was a very beneficial meeting that I met someone who's a practitioner in an Indigenous legal system in a very challenging environment. The Chittagong Hill Tracts are a very difficult place to be a female judge in particular. So I'll allow her to introduce herself better than I can. Ekin, the floor is yours.
Distinguished delegates, warm greetings. I speak to you today not only as an Indigenous woman, but as a traditional leader, headman from Chittagong Hill Tracts of Bangladesh. Thank you for your time and joining with us. I speak from a place of deep responsibility rooted in the ancestral land and customary law of my people, the Jumma communities who have lived in our hills, governed ourselves and resolved our disputes through our own traditional justice systems for generations. Today I wish to reflect on the report of the Special Rapporteur on the independence of judges and lawyers, especially on the right of Indigenous peoples to maintain and develop their justice system from the perspective of Bangladesh, especially from Chittagong Hill Tracts. So our justice is our identity. Under GR 39, Indigenous peoples have the right to develop, maintain, and apply their own justice systems as a part of broaden her right to self-determination, cultural integrity, and autonomy. States have a duty to recognize and support these systems, ensuring they are respected within the national legal framework provided they align with international human rights norms. Paragraph 14 of GR 39 states, Indigenous peoples have the right to maintain and develop their own judicial system or customs in accordance with international human rights standards. I'm deeply encouraged by the report presented by the Special Rapporteur on the independence of judges and lawyers, yet our systems are often ignored and undermined by the state in the CHD. Our customary leaders, circle chiefs, hetmen, karbaris operate in legal uncertainty even though we have a long history of indigenous governance. So the 1997 CHD Accord recognized our traditional systems, but implementation remains incomplete. That is the biggest challenge. Too often, national laws override our customs. Courts questions our authority. Now the situation we're going through, challenges faced by Indigenous women leaders in justice system. Indigenous women leaders like myself face double discrimination, both as indigenous and as women in position of leadership. As a woman, hetman in a traditionally male-dominant community, rural community, I knew from day one that I was stepping into a role few expected me to take, and even fewer were ready to support. And also there is gender-based challenges like a lack of acceptance. Many elders questions my authority simply because I'm a woman, and double standards minded, like decision praised when they made by the male leaders were criticized when I made them. So cultural pushback also another biggest reason, also challenges like some believed leadership was not for women. This is for just to, for male. And so refused to attend meetings. So yeah, this kind of happens in my area. Social isolation is another issue. Like there were days I felt completely isolated. The other leaders wouldn't consult me or include me in any kind of decision making. So I had to work twice as hard to prove I belonged. It was exhausting, but also empowering. But challenge reminded me I wasn't just leading for myself. I was breaking a path for the next generations of girls. Being a woman hetman wasn't just about leading a village. It is about challenging norms, values, shift mindsets, and providing that leadership has no gender. I work to ensure women included in decision making because that is very important. And nowadays, I think I'm doing work more and more so that I can ensure that So today I respectfully call the following, like full recognition of indigenous justice system in national law with legal clarity and respect for our jurisdiction, protection and support for traditional indigenous women leaders, especially so we can continue to serve our communities without fear and marginalization. Third one is meaningful dialogue between the state and indigenous communities, not to dominate us, but to work together with mutual respect. So yeah, I'm ending to conclusion, like indigenous justice is not something of the past, it is still alive today in our villages, in our stories, in the decisions we make every day. It is time the world sees us not as problems to be solved, but as people with solutions, with wisdom and law. We do not ask for special treatment, we ask for recognition of what we exist. Thank you so much for having your time.
Important to reflect that all the problems are not external. There may be some internal issues that need addressing as well, right? Our next speaker is a force of nature, Mariana Yumbai. I met her in one of the consultations on the report developed by the Special Rapporteur. As mentioned, she's a former judge on Ecuador's Supreme Court. She's now a member of Parliament, and I hope you give her a nice round of applause when she's finished. Mariana?
Gracias. Muy buenas tardes con todos y todas. Debo iniciar felicitando por el trabajo realizado a la señora relatora. Veo que se han recogido las grandes problemáticas que estamos viviendo en los distintos países. Estamos seguros que este aporte realizado contribuirá para que los estados nacionales modifiquen sus actuaciones y contribuyan al fortalecimiento del sistema de administración de justicia indígena y el estricto respeto a los derechos de los pueblos indígenas reconocidos en los distintos instrumentos internacionales. En el caso ecuatoriano, en el 2008 se reconoce al Ecuador como un Estado plurinacional intercultural. Plurinacionalidad que implica el reconocimiento de la pluralidad en los distintos ámbitos. Y ahí también el pluralismo jurídico, la existencia de distintos sistemas jurídicos en un mismo espacio territorial. En igualdad jerárquica, se supone que el sistema de administración de justicia indígena está reconocido en igualdad jerárquica que el sistema de administración de justicia ordinaria. La justicia indígena tiene relación con territorio, con autoridad, también con autonomía, y es un derecho milenario. Sin embargo, hay que señalar que hemos venido enfrentando un sinnúmero de dificultades, precisamente porque se ven en la práctica todavía violaciones a los derechos de los pueblos indígenas. Varias autoridades territoriales han sido criminalizados por ejercer la justicia indígena, por defender las tierras y territorios, entre otros, hasta por ejercer el derecho a la resistencia. En ese marco nosotros nos preguntamos, si bien es cierto la Constitución se ha desarrollado, se ha reconocido derechos, pero en la práctica se sigue vulnerando con instrumento constitucional a la mano, ¿no es cierto? Hemos visto también que las decisiones emitidas por las autoridades indígenas son desconocidas por el Estado. Ese es un permanente problema. Tal es así que se termina vulnerando el principio non bis idem, que nadie puede ser juzgado más de una vez, pero en la práctica se da. Hay autoridades del sistema de justicia indígena que por resolver un caso han sido procesados y hasta condenados por la justicia ordinaria. Se ha buscado también limitar la competencia de las autoridades indígenas, diciendo que ustedes no son capaces de resolver estos casos grandes, como los delitos que tienen relación con la vida, y se pretende dejarles en manos de los pueblos indígenas los casos chiquitos, los de bagatela, ¿no es cierto? Eso constituye, nosotros decimos, un retroceso inmenso, ¿no es cierto? Por otro lado, también ha habido casos en que miembros de los pueblos han hecho absolutamente nada. En este marco nos hemos orientado a trabajar en la erradicación de la violencia de los distintos tipos que sufre la mujer indígena, teniendo en cuenta que la mujer es la base fundamental del desarrollo de la familia y del desarrollo de la vida comunitaria, del desarrollo de la organización, entre otros. Para lo cual nos hemos enfocado a partir del fortalecimiento de los gobiernos comunitarios, incluyendo la participación activa de la mujer dentro de estos gobiernos, a fin de que sea activa en la toma de decisiones, no sea uno más o un número más en la asamblea, sino que sea es activa y en la toma de decisiones fundamentalmente. Al contar con un gobierno comunitario fuerte, nuestro objetivo es el fortalecimiento del sistema de administración de justicia indígena a fin de que se resuelvan los problemas de violencia que la mujer viene sufriendo con la misma entereza. Esto en virtud de que la mujer, que es objeto de la violencia de cualquier tipo, no acude a la justicia ordinaria, precisamente porque lo ve lejos, ajena a su realidad cultural, ha sufrido discriminación, revictimización, no tiene recursos económicos para sostener un proceso jurídico porque todo demanda de recursos económicos. Por eso, la mujer ha planteado que se requiere precisamente fortalecer el sistema de administración de justicia para que sus casos sean resueltos por sus autoridades, hombres y mujeres, de manera colectiva, teniendo en cuenta que se logrará recuperar la armonía y sanar el daño sufrido, así como que su reconocimiento es parte de la lucha de los pueblos indígenas. Se está llevando adelante procesos de formación continua en la implementación del sistema de administración de justicia indígena. Esto para garantizar que el acceso a la justicia indígena sea efectivo, eficiente y respetuosa también de los derechos tanto colectivos como individuales. Estamos trabajando en protocolos que permitan resolver de manera respetuosa los derechos de las mujeres. Se requiere contar con la coordinación y cooperación del sistema de administración de justicia ordinaria con la justicia indígena en los procesos de solución de conflictos, como por ejemplo para la práctica de algunas pericias, entre ellos médicos, ¿no es cierto? La pericia médica. Necesitamos que la justicia ordinaria contribuya en aquello. El Estado tiene una deuda todavía histórica con los pueblos indígenas y más aún con las mujeres. Por eso, si bien es cierto, el Ecuador está declarada como un Estado plurinacional e intercultural, sin embargo, no se ha asignado un centavo de dólar para el fortalecimiento del sistema de administración de justicia indígena. En ese sentido, nosotros hemos venido demandando que se debe cumplir y asignar suficientes recursos para el fortalecimiento, la implementación del sistema de administración de justicia indígena y también para garantizar que la vida de la mujer, de la familia, de los niños y de todo estén en condiciones plenas y se garantice al interior la armonía. Más aún cuando sabemos perfectamente que a lo largo de la historia la justicia indígena ha cumplido un rol muy importante, garantizar la paz y la tranquilidad, el control social al interior de las comunidades, es decir, ha venido subvencionando al Estado. Ahora más aún cuando en el Ecuador se ha fortalecido enormemente la delincuencia, la inseguridad en el área urbana, pero en el área donde están los pueblos indígenas, las autoridades están trabajando para garantizar la armonía. Muchísimas gracias a todos y todas.
We're coming to the end of the long day, but let me just editorialize slightly. The leading case from the UN system on indigenous justice systems is actually a case against Ecuador. It's called Yacu Perez versus Ecuador in 2022, where the Committee on the Elimination of Racial Discrimination upheld indigenous peoples' rights to maintain their own justice systems, and there's a corresponding obligation on the state to respect the decisions of indigenous justice systems and indigenous authorities. So I'd encourage you all to read that decision. It's a good illustration of how the Declaration is really restating existing international law and how there's a dynamic between the Universal Human Rights Treaties and the Declaration that's mutually reinforcing. And the Declaration is not the only instrument that can be referred to on these issues. Would Denmark or Finland like to make a closing remark? If you would like to, please do so from the floor. Thank you.
Yeah, thanks a lot. My name is E. Petersen. I'm the ambassador of Denmark, and we are very proud, together with our Finnish colleagues, to be supporting this. Working with IPGIA, which has been a long-time partner for Denmark. Personally, I've worked on and off with IPGIA for the past 25 years, so it's really great and a very, very important subject, I would say. I think I'm not an expert, and listen carefully there. But just one point to put things in context. What we are seeing now in the world in terms of geopolitical changes, in terms of what we call pushback on rights and privileges, or definitely rights that we thought were all agreed and really platform, just underlines also the need for keep the focus also, keep and we really welcome the report of the Special Rapporteur, aspects like Indigenous Peoples justice system. We like very much the approach of putting up good practices, but of course also all the challenges, because I think that's the way to move forward. What is possible in some places can hopefully be done other places, but not necessary. So I think that's a great step forward, and just want to thank you all for also the panelists for very interesting statements. Thanks a lot.
Many thanks. As promised, we have some time for questions. Would anybody like to ask a question? One here, one there, and then one over here. Yep.
Muchas gracias. Antes que nada, pues una buena tarde, un agradecimiento a la exposición de la relatora de independencia de jueces y abogados. Creo que permite tener un panorama bastante amplio del informe. Mi nombre es Rommel Loarca, soy de Guatemala y agradezco la última visita oficial que se ha tenido. Preocupaciones que siguen siendo latentes a nivel de Guatemala y creo que nos atañen a toda Latinoamérica y otros territorios, es que el aumento de la criminalización, la persecución política que se está dando para líderes y autoridades indígenas es algo muy, muy preocupante, pero al mismo tiempo nos genera el indicador de que defender la tierra, defender los ríos, defender la madre naturaleza no es un delito. Y no es que estemos en contra del desarrollo como pueblos indígenas, sino que es todo lo contrario. Estamos tratando de buscar generar condiciones de vida digna para todas y todos, pero al mismo tiempo creo que esto permite en algún momento identificar que hay espacios de articulación conjunta, y creo que acá valoramos y agradecemos también la participación del relator de pueblos indígenas, que ha permitido pues, darle seguimiento justamente a las denuncias como pueblos indígenas, pero también creo que es necesario dar recomendaciones a los gobiernos, a los estados en este caso, que puedan ratificar acuerdos regionales como el acuerdo de Escazú, que justamente para Latinoamérica sería en algún momento pues, el espacio para poder tener la protección para defensoras y defensores de derechos humanos. De igual forma, en los países, pues darle seguimiento a las mesas de empresas y derechos humanos también, en este caso, porque las empresas en algún momento son las que están llegando a los territorios a generar grandes violaciones de los derechos de la naturaleza y los derechos ambientales, pero también son quienes a través de una componenda con los estados pues obtienen las licencias para poder trabajar en territorios en su mayoría de pueblos indígenas, en donde se están dando desalojos, en donde se está dando criminalización una vez más y en donde se está despojando de la tierra una vez más a las personas que tienen históricamente años o miles de años de vivir o habitar en estos territorios. Hay espacios como asambleas de pueblos en diferentes territorios, en este caso agua para la defensa del agua, la vida de los territorios, pero de igual forma queremos hacer mención que hay organizaciones que han estado dando seguimiento a nivel de Latinoamérica, Plataforma Internacional contra la Impunidad, Asociación Comunitaria para el Desarrollo y así diferentes organizaciones que se han estado vinculando, en este caso como Serjus, necesitan en algún momento la observación. El CITI, que nos han dado la oportunidad, y también agradecemos a quienes han dado la oportunidad en este foro, nos han dado la oportunidad de poder participar, pero también incitamos para que desde las mismas relatorías pues, se pueda dar la recomendación a las mismas autoridades de gobierno para poder, en este caso, pues garantizar la protección de defensoras y defensores. Muchas gracias.
Thank you.
Good afternoon. My name is Javier Krong and I am the Monsignor Human Rights Advocate and Indigenous Rights Activist. I have one question. Like many Monsignors, lawyers and activists living abroad, who engage in peaceful advocacy for our fundamental human rights are being convicted in absentia by the Vietnamese authority, the Vietnamese government, and is baseless, charged with terrorism. This isn't about general crime, I would say. It's a deliberate attempt to defame our activism and also discredit our work and leverage the international system. So, some people are being rejected, their asylum status and claim and their resettlement application has been rejected by the third countries because of this baseless and it's sad to say, but so my question is that how can this panel and the international bodies that we represent effectively intervene and to challenge these political motivated convictions in absentia and protect international activists and lawyers in abroad that are being persecuted by their country of origin and even on the foreign land. So what specific guidelines that can you offer in the host countries like Switzerland and other European countries or the US to ensure they understand this calculated transnational repressions and refuse to be complicit in returning activists to certain imprisonment and thank you.
Thank you very much for both of those comments. I think they have some things in common that are really important. I think the issue of criminalization is a huge one. There is something that people often call judicial harassment or legal harassment, which I'm trying to call instrumentalization, criminalization. I think it's important that we talk about it very clearly. It's when the criminal law is directly misused in order to persecute individuals for the rights that they are claiming. It's a very, unfortunately, common practice in many places. And I think you pointing it out in these two very different countries is important. The issue of transnational human rights violations is enormous as well, and I really appreciate you bringing that up. I think the more that we can articulate this as a human rights violation, the misuse of criminal law in order to silence, use reprisal against human rights defenders, against indigenous leaders, the more we'll be able to make clear that this is in itself a human rights violation, and thus, in cases that you're speaking about of asylum applications, it should be recognized as persecution as well. That would be my take on that. Thank you.
Let me just add very quickly to that. My organization, Indigenous Peoples' Rights International, was established by Victoria Taulico-Cruz and Joanne Carling, largely to deal with the issue of rampant criminalization of Indigenous peoples around the world. So it's a subject we deal with almost every day. And what's happening in Vietnam and its neighbors, and not only, is all too common. In fact, part of the reason EMRIP was created is the government of the Philippines put Vicky and Joanne on a terrorist list, while Vicky was the Special Rapporteur, no less, right? So we're quite familiar with these different stories. The reason I'm talking now is there's a case that was filed in the Committee Against Torture about the sending a Mapuche woman from Switzerland back to Chile where she would be persecuted. And part of the issues that were raised in that case were criminalization issues as well. So if you're experiencing that in Switzerland, provided you exhaust the domestic remedies, the Committee Against Torture has a precedent which you could follow to not be returned to countries like Vietnam, where they're putting lawyers in jail for practicing their profession, et cetera, et cetera. There's another case against Mexico involving criminalization of indigenous peoples in the Committee Against Torture as well. So there are potential remedies there if you want to use them and you know how to use them. But this issue of criminalization is not simply one that's in Southeast Asia or in Guatemala. It's happening in the United States. It's happening in other places on an increasing and alarming level in some degrees. So it's something that needs attention in all human rights fora and in all the discussions that we engage in. If we don't deal with this issue of repression through criminalization, through misuse of the criminal justice system, we're actually missing a large chunk of the human rights issues that are being raised. I'm very grateful that Meg's report deals a lot with those criminalization issues, because there are indigenous peoples being criminalized for being a traditional judge in their community, for exercising their indigenous legal system, even in countries like Ecuador, where it's guaranteed by the Constitution. So these are very real and very present issues. We had one question here, and then one there, and then I think maybe we should finish up. Okay, one over here.
Muchas gracias. Yo soy Jonal Ortiz, abogado indígena de la Amazonía venezolana. Bueno, el caso venezolano, de la parte que creo que la actualización del alto comisionado ha sido muy extensa con respecto a la situación real de lo que está ocurriendo en Venezuela, pero también en el tema de pueblos indígenas y específicamente en el área de justicia indígena. En Venezuela, desde el año 1999 se reconocen los derechos de los pueblos indígenas. De hecho, en el artículo 260 se establece la justicia indígena, pero esto realmente no se ha desarrollado, no porque nosotros como pueblos indígenas no hemos querido desarrollarlo. Incluso yo, siendo abogado, tuve la oportunidad de formar un tribunal en situación por un caso de un hermano indígena que prácticamente lo dejó morir el Estado venezolano en una de las peores cárceles de Venezuela por acusarlo de terrorismo, y esto fue producto de la masacre del año 2019, que fue esta masacre que se debatió aquí en Naciones Unidas y que fue la que dio a la misión de determinación de hechos en Venezuela y la que ha venido actualizando. Ahora bien, yo más que pregunta, yo quisiera invitar a la relatora. Sé que la situación de Venezuela es muy compleja, evidentemente no lo van a invitar ni siquiera a un foro académico, pero sí hay bastantes abogados indígenas, hay muchísimos defensores, no solamente que están siendo acusados de terroristas, sino también situaciones que ya hoy es claro que la situación vamos a decir, del organigrama que se tiene estructurado para Venezuela con respecto a la justicia indígena no se ha dado. Nosotros hemos avanzado, sin embargo el Estado venezolano no ha querido hacer nada, solamente habla de justicia indígena cuando le conviene, habla de jurisdicción indígena cuando le conviene, pero en la realidad nosotros, como lo decía Guatemala, como lo decía la hermana del Ecuador, nosotros prácticamente estamos a la expensa de una jurisdicción ordinaria, la cual no tiene ni siquiera un sistema de separación de poderes, que solamente es con una llamada telefónica, sencillamente a un defensor, a un indígena, a una persona civil, por el hecho de decir qué es lo que está pasando en nuestro territorio, nos acusan. Yo particularmente tengo 2 medidas de protección internacional. Fui acusado recientemente conjunto a mi organización como terrorista solamente por defender los derechos humanos. Muchas gracias.
Good afternoon. Thank you for this opportunity and thank you for your presentations this afternoon. My name is Sandra Delarond and I'm the team lead for Ganawe Mananig, which primary objective is to advance the 213 calls to justice from the National Inquiry. The National Inquiry into missing and murdered Indigenous women, girls, and gender diverse people released its final report in 2019. And its primary finding was that of genocide against Canada and its state agents. Having said that, we continue to see an increase in violence against Indigenous women, girls, and gender diverse people in our country, and I would probably say that that would be the same for Indigenous women worldwide. I would like to pose a question on the independence of judges and lawyers, because we find that as victims, less than 1% of cases that are brought before the courts have a finding of guilt against the perpetrators. So I look at that as a systemic response to violence. How would you see the judiciary, the lawyers, the crowns becoming better informed, trauma-informed, understanding those systemic issues? And in fact, I think by the statistics continue to perpetrate genocide, how do you see the system changing? What would your recommendations be?
Thank you very much. That's such an important comment that you've made, and my guess is that the recommendations in the report would be the answer. But in terms of judges and lawyers and prosecutors, which I also have in my mandate, one of the #1 recommendations is absolutely that they have to be educated and learn about Indigenous peoples, including what are the rights of Indigenous peoples in ordinary systems. And I have to say, in all of the consultations, the examples that were brought up over and over again of judges, lawyers, and prosecutors acting with frank, straight-out racism, in addition to ignorance and just a lack of understanding, it was absolutely constant. I think in every consultation there were some very, very upsetting examples. And yet again, I heard over and over again about commissions, committees, reports that Indigenous people have led or have been part of making recommendations to overcome these things. So I guess just in a closing remark, it is, as my colleague, the Special Rapporteur on Indigenous Peoples said, this is within my mandate. So if you would like to think about communication, please do approach me and write to my official email. I'm very interested in taking up these issues if possible. I recognize that a communication is a very weak, it's a weak answer to genocide, certainly, but it could be perhaps a way of amplifying some of those recommendations. Thank you very much. And similarly, I'd love to talk with you about the situation in Venezuela as well. Thank you.
Gracias. Refiriéndome a la pregunta planteada por la señora, en el caso ecuatoriano nosotros hemos señalado que para lograr disminuir la criminalización y que se pueda dictar sentencias con interpretación intercultural y que se respete las decisiones del sistema de administración de justicia indígena, es necesario que las universidades y todo el sistema educativo jueguen un rol muy importante. Ahí hay que preguntarnos, las universidades, ¿qué tipo de formación están dando? ¿Qué abogados están entregando a la sociedad? Abogados formados en un estado monista donde se desconoce la existencia de los distintos sistemas jurídicos. O sea, eso es lo que habría que cuestionar y nosotros hemos dicho, aquí tienen que todos involucrarse para acabar con estas taras, acabar con el racismo, con la discriminación, pero también en el caso ecuatoriano hay la escuela judicial dentro del sistema de administración de justicia ordinaria. Hemos exigido que dentro del pensum de esta escuela judicial tiene que insertarse materias como pluralismo jurídico, derechos colectivos, consulta previa libre informada, consulta prelegislativa, y que conozcan las sentencias dictadas por la misma Corte Interamericana de Derechos Humanos, por las altas cortes constitucionales, para que conozcan. Caso contrario, siguen habiendo jueces monistas que no quieren entender que aquí, antes de las constituciones de los estados nacionales, los pueblos indígenas ya estábamos ahí en los distintos territorios. Es lo que venimos demandando y vamos a seguir en esa lucha. Caso contrario, no vamos a cambiar. Nada más, gracias.
Okay, two more. Dos más. Breve, por favor.
Buenas tardes, relatora especializada de independencia de jueces y abogados. Mi nombre es Edison Vargas Huamanga, yo vengo del Perú. Soy un líder indígena de mi pueblo. Nosotros, como indígenas, hemos apostado por una minería extranjera china, desde el gobierno chino MMG Las Bambas. Por reclamar mi territorio, actualmente me encuentro como un líder indígena con 70 procesos, con 70 denuncias, criminalizado, amenazado mediante redes sociales y mediante prensas nacionales de mi país. Y no solo eso, nosotros no podemos tener, como líder indígena, no podemos tener un abogado, un asesoramiento. Igual se encuentran mis abogados criminalizados, extorsionados. Y actualmente tenemos fuertes denuncias y hasta nos están haciendo pasar por terrorismo la empresa extranjera china, MMG Las Bambas. Y igual, actualmente el gobierno, el Estado peruano, no nos está haciendo cumplir nuestros compromisos. Cuando nosotros reclamamos nuestro derecho, cuando nosotros reclamamos por los acuerdos que hicieron con mi pueblo indígena, la empresa extranjera china, prácticamente somos acusados, prácticamente somos criminalizados. Nosotros no podemos levantar ni un voz, no podemos ni protestar. Estamos reprimidos actualmente. Y actualmente, hoy he venido acá para poner toda esta denuncia, esta justicia. Lamentablemente, capaz llego a mi país, voy a ser reprimido o voy a estar detenido de mi Estado peruano, igual de la empresa extranjera MMG Las Bambas del gobierno chino. Nada más quisiera participar. Muchísimas gracias.
Last one. Please tell him I'm happy to have a chat with him later if he wants to. Last one, please.
Thank you very much. My name is Maria. I'm from the Permanent Commission of Finland. I would like to thank you for this opportunity to co-sponsor this event, and thank you for the thanks to the Special Rapporteur for her timely report. And in that context of the report, I would wish to highlight, maybe on a positive note, a positive example from Finland. Because in Finland, recently the Finnish Parliament approved changes to the Act on the Sami Parliament, strengthening the self-determination of the Indigenous Peoples through, among other things, the establishment of an appeals board for electoral roll matters of the Sami Parliament. So I'm happy to note that we have finally managed to fulfill our obligations related to the self-determination and human rights of Indigenous Peoples, the Sami, and this is a historic moment for Finland. Thank you.
Okay, thank you. In closing, we all join with you in being very thankful you finally addressed the issue in Finland, so well done. Thank you for that. If anyone has one last question, otherwise I think we're finished for today. One last question? Anyone? No? Okay, anyone want to bang that? I think we're done for today then. Thank you all for coming. It's a very nice turnout, especially so late in the day. And we wish you much success, both when you go home and while you're here.